Okay, well, let's get started then. So welcome to the Temporary Foreign Worker Program webinar information session. My name is Colin Bond. I'm the Workforce Development Coordinator here at the Federation of Agriculture. Just want to let you know before I introduce our guests that we will follow up after the presentation with a question and answer period. Also that we are recording this, so it will be available on our website. I'm hoping next week if nothing technical goes wrong. So let's get started. I'll introduce our presenters. Both are from Service Canada. So we have Chloe Poirier. She's the Business Expertise Consultant with Integrity Services for the Atlantic region. And we also have Mark Douglas, who's Senior Program Advisor with Compliance Operations. So I'd like to thank both of them for being here today. And we'll get started, I guess. Go ahead, Chloe.
Thank you guys for joining us today for the presentation. My name is Chloe, and Mark is also here for the presentation today. I'm going to share my screen because we do have this PowerPoint to sound muffled. Technical. See if I can try and change something with my settings.
So just down at the bottom of it should say share screen, and you can share that.
Can anyone else, does anyone have a hard time hearing me right now though? I just want to make sure that I don't sound too muffled.
Yeah, it sounds a bit muffled on my end.
Kind of see what the options are for the mic settings coming soon.
If it's any help, Chloe, if you mouse down to the bottom, you'll have a pop-up, and on the left side, you'll have something that says mute with a little arrow beside it. If you click the up arrow, you can adjust your microphone to make sure you're on the right microphone.
I think I changed the setting.
Better already.
Perfect. That's great.
Oh my God. Great. Technology, not my strong suit, guys. But thanks very much for your help. All right. So I'm gonna just pull everything up. Okay. So just want to make sure everyone can see the screen as well. We're all good. Perfect. Okay, we're gonna get started then. So the objective for today's presentation is to provide you guys with information about the Temporary Foreign Worker Program inspections. So we're going to give you an overview on the inspection process, talk about common areas where we see non-compliance, and we're also going to talk about the new regulatory amendments that went into force on September 26, 2022, as well as the new recognized employer pilot. So our is from the Immigration and Refugee Protection Regulations. So to ensure compliance and worker safety, we work with partners, which include our federal partners. So that would include Canada Border Services Agency, the Royal Canadian Mounted Police, and Immigration, Refugee and Citizenship Canada. We also have provincial and territorial partners, so that would include workers' compensation and employment standards. And we also have our municipal partners, including local public health units and municipal housing inspectors. Our role is to protect the health and safety of temporary foreign workers by ensuring employer compliance, to verify that employers are following the rules of the program, and to protect the Canadian labor market. So our authority is strictly administrative, so we cannot prosecute criminal cases. So our purpose is to ensure employers' compliance with program conditions. Non-compliant employers are provided with an opportunity to provide justification for their non-compliance. So we can only penalize or ban non-compliant employers from using the program. So we do refer criminal cases to our partners at Canada Border Services Agency, the RCMP, or local police. So what would trigger an inspection? So according to the regulations, there are 5 reasons for Service Canada to launch an inspection. So the first one being we've received a tip or a lead that a business has not been complying with their LMIA. Tips and leads can originate from news outlets, provincial partners and stakeholders, foreign consulates, and third parties. We also receive them through our tip line and our online reporting tool. Another trigger is an earlier inspection has found that the employer was non-compliant. So employers who have previously been found non-compliant and have returned to the program can be inspected to ensure that they are now following the rules of the program. The employer could also be selected for a random inspection. So we use a risk modeling system that identifies occupations and industries, and it randomly selects employers for inspections. When the Quarantine or Emergencies Act are in place, Service Canada can also conduct inspections based on those acts. So those are number 4 and 5. So inspecting employers whose TFWs are or were subject to the Quarantine or Emergencies Act. This means that we can inspect employers who have brought in workers who needed to quarantine to ensure that they are protecting their workers. And lastly, the introduction of communicable disease where the TFW works. So, for example, when we find out that there is someone infected with COVID-19 at the TFW's workplace. So all of our inspections have 4 distinct phases. So these include the first phase being the initiation phase. So this is where the inspection is triggered and assigned to an inspector. So during this phase, the inspector will determine why the employer was identified for an inspection. They'll check past interactions with the employer. They're going to familiarize themselves with the employer's LMIA, and they're going to contact the employer to advise them of the inspection. We'll move on to the second phase, which is the information gathering phase. So during this time, the inspector will work with the employer to gather information about their case. Activities could include interviewing the employer, interviewing the workers, collecting documents from the employer to determine compliance, and inspect the employer's business premises. We're then going to move to the decision-making phase. So during this phase, the inspector will review the information gathered and make a determination about whether or not the employer is compliant. So if the employer is not in compliance, the inspector will give the employer an opportunity to provide justification for the non-compliance. If the employer is still not compliant after providing justification, the inspector will send them a notice of preliminary findings, and that will outline the potential consequences. And it will also provide the employer with one last opportunity to provide new information. If new information is presented at this time, the inspector may return to the information gathering phase for further clarification. And finally, the last phase is the inspection complete. So once a decision has been made, the employer is notified of the decision. And if they are not compliant, they will be notified of the consequences. So we conduct both announced and unannounced on-site inspections. So if an employer is selected for an announced on-site, the inspector will contact the employer before arriving to explain why they've been selected for an inspection, what the employer will have to do, and the date of the inspection. So if the employer is selected for an unannounced inspection, they will not be notified about the on-site inspection until the inspector arrives at the work site. When we arrive, employers must let our inspectors onto the work site to see where the workers work, and if the employer provides accommodations, where they live. We will take photos or videos, collect documents, and interview the employer and the TFWs when we're on site. The employer is expected to provide reasonable assistance and access to the inspector. So this means working with the inspector to help the inspection go smoothly. This would include giving the inspector access to documents and their employees for private interviews. An employer who has been notified of an inspection who does not show up or give access to the worksite and workers will need to provide justification for their actions. So depending on the type of inspection and the program stream, Service Canada can inspect up to 28 conditions. So although we can inspect up to 28 conditions, we'll generally inspect a much smaller number based on the stream used to access the program and also the employer's circumstances. So the most common conditions that we would inspect are elements such as wages, working conditions, so that would include overtime, vacation pay, hours of work, things like that. We would also look at provision of an abuse-free workplace and adherence to federal, provincial, and territorial laws. So those are some of the more common things that we look at. So when we're conducting inspections, we are looking for the employer to prove that they are complying with their LMIA. So this means that they must prove that they've been paying their workers as per the approved LMIA, that the TFW's working conditions match what was in their contract and their LMIA, that the employer is following the employment laws of the province or territory in which the worker is working, that the employer has taken appropriate steps to provide an abuse-free workplace, and that the workers are working in the correct occupation. So if we identify non-compliance during the inspection, the employer is given a chance to justify why they were non-compliant. So they are asked to provide a detailed explanation as to why they were not compliant, and also explain what actions they have taken to rectify the non-compliance and prevent it from happening again. If the employer provides a credible, acceptable justification in accordance with the regulation for each condition that they were not in compliance, they will be found satisfactory. If the employer justifies their non-compliance due to an error made in good faith, and they are found to be non-compliant for the same condition in the future, the same justification won't be accepted for a second time. For example, if an employer failed to pay a worker properly due to an administrative error, say they inputted the incorrect wage, they would need to explain to the inspector what caused the administrative error, what they've done to ensure that it does not happen again in the future, and demonstrate that they have compensated the negatively impacted worker. So justification recognizes that employers can make mistakes, and it provides them an opportunity to rectify an error made in good faith. So this helps protect workers by providing the employer an opportunity to make things right when an error has negatively affected the worker. So if the employer is still not compliant after submitting justification, they will be sent a notice of preliminary findings that outlines the consequences of non-compliance. So this notice is the employer's final opportunity to provide new information that may change the decision. Any new information submitted is objectively reviewed to determine whether it changes the outcome of the case. So during this process, the inspection will be reviewed to determine if the information provided affects the outcome of the inspection. So the new information can result in a change in the consequences for any non-compliance. It can result in a cancellation of the penalty and or ban if the new information demonstrates that the employer was compliant. It can result in a reduction of the penalty and or ban if the new information demonstrates partial compliance or shows that the employer has taken steps to make things right for the affected TFWs. It could also potentially result in an increase if the penalty and or ban, if the new information demonstrates further non-compliance, or it could result in no change if the new information provided does not impact the decision. So if the employer is still not compliant after the notice of preliminary findings, they will receive a notice of final determination that advises them of any penalties. So if after responding to the notice of preliminary findings, the employer is still found non-compliant, they can face a penalty and or ban from the program. Non-compliance with any of the conditions can result in penalties of up to $100,000 per violation to a maximum of $1 million per year in the case of multiple violations. The employer could also face a ban that ranges from 1 year to a permanent ban in the most severe cases. Non-compliant employers will also have their business details posted on the IRCC public website. The website will outline the consequences of non-compliance and why the employer was found non-compliant. We're now going to go into a hypothetical example of how non-compliance can impact an employer. So for this example, the employer in question was classified as a small business and was selected for a random inspection. So when contacted, the employer refused to send documents or participate in the inspection. The inspector working on the case sent multiple requests for information from the employer. And when they refused, the inspector scheduled an on-site inspection. On the day of the inspection, the employer did not show up for the inspection and had instructed their employees to turn away the inspector. The inspector then sent the employer a registered letter directing the employer to a Service Canada Centre to provide needed documents and to respond to the inspector's questions. The employer again failed to show up. The employer was then sent a justification letter to which they failed to respond. Finally, a notice of preliminary findings was sent to the employer, and the deadline for that response passed as well. So in this example, the employer would be assessed a violation for 3 conditions. The employer was assessed an administrative monetary penalty for each condition of $15,000 for a total penalty of $45,000 in this particular example. It's important to note that as with all inspections, the employer had multiple opportunities to provide information to the inspector, and had they done so, they may not have been found non-compliant. In the event that you discover that you haven't been complying with the terms of your LMIA, voluntary disclosure can be used to mitigate the consequences. So a voluntary disclosure, it recognizes that employers can make mistakes, and provided that an inspection isn't underway and you've taken the steps to correct the compliance issue, it could mitigate the consequences of non-compliance. So if you discover that you haven't been complying with your labor market impact assessment, please take corrective actions and contact an employer contact center to advise them. You may be inspected as a result of your voluntary disclosure, but the consequences of any non-compliance will be mitigated based on the following factors. So the completeness of the disclosure will be taken into account, the impact on the TFWs and the Canadian labor market, the timeliness of the disclosure, how many times you've used voluntary disclosure in the past, how you corrected the issue and ensured it doesn't happen again, and also what conditions you failed to comply with. Please note that if an inspection has been launched or you are already the subject of another action under the Immigration and Refugee Protection Act, you may not be eligible to a voluntary disclosure. So I'm now going to talk about some of the recent changes to the program, including the regulatory amendments from September 2022, as well as the new recognized employer pilot. So the new regulatory amendments to the Immigration and Refugee Protection Regulations went into force September 26, 2022. These amendments add new LMIA requirements and employer conditions. So the goal of these amendments were to improve protections for temporary foreign workers, enhance program integrity, and also clarify employers' responsibilities. Some of the amendments will impact employers during the LMIA application process. So the labor market impact phase of the application process has been changed. So the assessment against the prevailing wage and whether the hiring of the TFWs will impact a labor dispute, these are now separate assessments, and a negative assessment in either of these will result in an overall negative assessment. Additionally, new employers will also be assessed under two new requirements. So the first one being whether the employer has made reasonable efforts to provide a workplace free of abuse, and that the new employer is not an affiliate of an employer who is ineligible for the program or in default of any amount payable in respect of an administrative monetary penalty. So again, a negative finding in either of these assessments will result in an overall negative assessment. So several additional protections for TFWs have also been implemented as part of the amendments. So the first one being for LMIAs confirmed on or after September 26, 2022, you will need to commit in your LMIA application to sign an employment agreement with your TFWs and provide them with a signed copy in the official Canadian language of their choice, so either English or French. This will have to be done on or before their first day of work. Some of the key elements needed in the employment agreement. This includes information about the job offer, so their job title and the description of main duties. Information about wages, including overtime pay. Information about working conditions, so expected work schedule, hours of work, vacation, and other benefits. You can also find a sample of an agreement that you can that will be updated. It's now available on our website. So if you want a sample to see what an agreement should look like, there is one available on the Service Canada website. Secondly, you will need to provide your TFWs with information about their rights in Canada. on or before their first day of work. So this information must also be available for the duration of the employment in both official languages. So by providing them with a copy of Know Your Rights on or before their first day of work, and posting a copy in both official languages at the worksite that is current and up to date, this will satisfy this condition. Next is the definition of abuse. It now includes a direct reference to reprisal. And you must not directly or indirectly charge or recover LMIA recruitment fees. You must also ensure that any person or entity that has recruited the TFW on your behalf does not directly or indirectly charge or recover these fees as well. You must also provide reasonable access to healthcare. So this can mean providing access to a telephone so that a TFW injured at the worksite can contact medical assistance. This doesn't require you to pay for the ambulance if the TFW requires one. You just that they have the tools needed to access medical assistance. And finally, there is now a requirement for all TFWs that you are obligated to pay for private health insurance for the TFW that covers emergency medical care for any period that the TFW is not covered by the provincial healthcare. So Employment and Social Development Canada and Service Canada may now require any individual or entity to provide any documents in their possession that relates to employer compliance. So this means that Service Canada can directly contact banks, payroll companies, etc., to request documents that relate to compliance. So for example, if Service Canada has reason to believe that a payroll company has information about an employer's payment of wages, Service Canada inspectors can directly request that information from the payroll company and require that they provide it. We will still continue to adhere to the Privacy Act regarding the use, storage, and disposal of any documents obtained this way. The regulatory amendments have also given ESDC and Service Canada the authority to suspend LMIA processing of LMIA applications, provided that the following conditions are met. So Service Canada has reason to suspect that the employer is non-compliant with one or more of the following conditions. That the employer is actively engaged in the business in respect of which the offer of employment was made. That the employer is providing working conditions that are substantially the same but no less favorable than those set out in the offer of employment. That the employer has made reasonable efforts to provide a workplace free of abuse and compliance with the COVID-19 related conditions. And that a failure to comply with any of these conditions I just mentioned would put the health and safety of TFWs at serious risk if a work permit was issued. On August 8th, 2023, the recognized employer pilot was announced. The pilot will be available to employers who meet the highest standards of wages, working and living conditions, and worker protection. The purpose of the pilot is to be more responsive to labor market shortages and to reduce the administrative burden on participating employers. So the pilot will run for 3 years starting September 2023 with phased access based on the program stream. Wage stream employers who meet the criteria, they were able to access the program effective January 2024. Employers who wish to participate in the pilot must have no history of non-compliance. As part of the application process, the employer's history of the program will be reviewed, including any prior inspection results. If an employer hasn't been inspected, their LMIA application history will be reviewed. Employers with a history of non-compliance may be deemed ineligible. This includes if they've received negative LMIA decisions on the basis of inadequate housing reports, worker protections, working conditions, wages, etc. If they've been found non-compliant in previous inspections, or there have been significant and credible allegations received against the employer for putting the health and safety of TFWs at risk. Employers who do not qualify for the pilot can still qualify for regular LMIA processing through the TFW program. So the recognized employer pilot check-ins are intended to be simple verifications of the commitments recognized employers have made, where employers will be required to attest and provide proof of documentation where applicable to confirm compliance with their commitments. In the event that the employer cannot provide acceptable justification for any issues found during a rep inspection check-in, or make corrective measures where appropriate, the employer may lose their rep eligibility and will be referred to the Compliance Operations Division for compliance inspections. Employers who are non-responsive or who do not agree to participate in the check-ins may face immediate removal from the pilot and will be subject to further inspection requirements. So we're going to now go over some compliance statistics and where we commonly see non-compliance issues. So from April 1st, 2022 until March 31st, 2023, Service Canada has identified the following trends for the program as a whole. So out of the inspections that we have completed so far, 48% of employers have been compliant. 47% have needed to provide justification before being found compliant. And 5% of employers have been found non-compliant. So the top 5 reasons requiring justification have been for conditions, the working conditions, wages, compliance with federal, provincial, or territorial laws, document retention for a period of 6 years, and provide any documents required. The 5% of employers who have been found non-compliant were found non-compliant for provide any documents required, working conditions, wages, document retention for a period of 6 years, and compliance with federal, provincial, or territorial laws. So from April 1st, 2023 until December 31st, 2023, Service Canada has identified the following trends for the seasonal agriculture worker program and agriculture stream. So out of the inspections that we completed so far this year, 41% of employers were compliant, 52% needed to provide justification before being found compliant, and 7% of employers were found non-compliant. So the top 5 reasons requiring justification were for working conditions, wages, compliance with federal, provincial, and territorial laws, document retention for 6 years, and document production. The 7% of employers who have been found non-compliant were found non-compliant for working conditions, document production, document retention for a period of 6 years, compliance with federal, provincial, and territorial laws, and an abuse-free workplace. And from April 1st, 2023 until December 31st, 2023, Service Canada has identified the following trends for the SOP and AG streams in Atlantic Canada only. So out of the inspections that we have completed so far this year, 17% of employers were compliant, 81 needed to provide justification before being found compliant, and 2% of employers were found non-compliant in the Atlantic. So the top 5 reasons requiring justification have been for working conditions, wages, compliance with federal, provincial, territorial laws, document retention, and document production. The 2% of employers who have been found non-compliant were found non-compliant for working conditions. So if you are responsible for providing TFW accommodations, the inspector will need to inspect that the accommodations provided meet provincial standards and are in good repair. So some of the common issues that Service Canada has identified in the past include non-functional or partially functional appliances, missing or non-functional fire extinguishers or alarms, insufficient laundry facilities, missing screens on the windows, blocked fire escapes or blocked windows, no working heat or hot water, or pests such as vermin or bugs. So we do recommend that you periodically review the state of your TFW accommodations and ensure that they are tidy and in good repair. If for some reason you need to make changes to the accommodation, particularly if you need to move the TFWs, you must contact Service Canada and provide a new housing inspection report as soon as possible. For SOP TFWs, you can deduct for utility costs according to the SOP contract. For agriculture TFWs, you cannot deduct for basic utilities. However, if the TFW requests something additional, such as a particular movie channel, you can deduct, provided you get the TFW's agreement in writing. Employers using the agriculture stream must pay for transportation from the TFW's country of residence to where the work will be performed. SOP employers must pay for transportation from either Mexico City for Mexican contracts or Kingston, Jamaica for Caribbean contracts. If you are employing SOP workers, you may recover up to 50% of the total travel cost from workers' wages over the period of employment, up to a maximum amount specified in the job offer. So make sure that you're double checking what the maximum amount that you can deduct for SOP workers. Employers using the agriculture stream, you may not recover any costs associated with transportation for workers. So again, it's important to refer to the employment contract for details about this. As the employer, you are responsible for any transportation from off-site housing to the work site. So if a foreign national elects to find their own housing rather than using the employer-provided housing, you're no longer responsible for daily transportation to and from the work site. Please retain documentation demonstrating that this was done at the TFW's request. You must also pay for the TFW's transportation home, even if the TFW quits or is terminated before the end of the contract. So the SOP and AG contracts, they lay out the minimum number of hours to be worked. It is important to refer to these contracts to ensure that you are providing enough hours to your TFWs. So the contracts explain the minimum and maximum number of hours that a TFW can work. And it is important that the TFWs not work excessive hours. In urgent situations, with the agreement of your workers, you can offer additional hours or postpone a day of rest. You must clearly document the reason why you need additional hours or why days of rest must be postponed. You also need to obtain the TFW's permission for the additional hours or to postpone the day of rest. So this additional work must be voluntary. You must obtain permission for each day in writing from each TFW. Also, you cannot exceed the maximum number of hours of worked in a day according to the provincial employment standards. So it is your responsibility to ensure that your TFWs have appropriate medical coverage. If you're employing SOP workers, coverage is dictated by the SOP contract. SOP employers may be able to recover some of the cost of health insurance from the TFWs. It is important that you review the contract to ensure that you are recovering the appropriate amount. Agriculture stream employers are not able to recover the costs, however. If there are healthcare expenses required before the TFW is covered by the appropriate provincial territorial insurance, you cannot recover any of those costs from your TFWs. If a TFW requires healthcare, they must be able to access these services. So this may mean that they may need transportation to a medical clinic or to the hospital. Please ensure that you have a plan in place to transport a TFW to treatment if necessary. The SOP program has some specific requirements. So for Mexican workers, you must provide them with transportation to a medical clinic or hospital. For Caribbean SOP workers, you must make arrangements so that they receive timely medical assistance. So please refer to your contracts with your workers for specific expectations. I went ahead. So as a user of the Temporary Foreign Worker Program, you must ensure that you have workplace safety insurance. So for Nova Scotia, it would be the Workers' Compensation Board of Nova Scotia. So that has to be in place when required by law. When required by law, you must use the provincial territorial plan. If you are required to provide workplace safety insurance, but are not required to use the provincial territorial plan, you are required to obtain private workplace safety insurance that is the equivalent to provincial territorial plans. And if you are not required to provide workplace safety insurance, you are required to provide proof that you are exempt from providing workplace safety insurance. If you hire a TFW, you agree to pay at minimum the LMIA confirmed wage. So while the LMIA system only supports an hourly wage, we do recognize that not all industries pay an hourly wage. So if the industry standard for your industry requires a piece rate or other alternative wage structure, it is acceptable to pay according to that structure as long as the wage paid equals at least the hourly wage confirmed on the LMIA. So for example, if the LMIA confirmed wage is $12 an hour and you pay a piece rate, if the TFW works 8 hours and earns $112, that is acceptable as it exceeds $96 they would otherwise be entitled to. So on the other hand, if the piece rate would only equal out $88, you would need to top it off to $96 to meet the LMIA confirmed wage. In addition to meeting the LMIA confirmed wage, you must also meet the prevailing wage if it changes after the LMIA was issued. This is particularly important for agriculture. In order to ensure that farmers are able to secure their workforce, Service Canada approves LMIAs based on the previous year's national commodities list. As an employer using the primary agriculture stream, you are responsible to update the wage to reflect the current year's commodities list. You must also pay at a frequency that is acceptable to meet provincial employment standards. If you agree to a pay advance with your workers, you must retain documentation that demonstrates that they agreed to the advance, proof that you have issued payment to them, and any repayment arrangements. So in addition to your obligations spelled out in your LMIA, you must also ensure that you are following the labor or employment standards governing your industry and work location. So this covers elements such as overtime, statutory holiday pay, vacation pay, breaks and days of rests, wages due to a change in the minimum wage, deductions from pay, and hours of work. Additionally, some provinces have enacted legislations that require registration with provincial authorities before recruiting or hiring temporary foreign workers. So please ensure that you are familiar with the federal, provincial, and territorial requirements. You must keep documents to demonstrate your LMIA compliance. Keep these documents for a period of 6 years. Please note that it is a federal requirement of the program and may exceed other record-keeping requirements. So some examples of documents that are important to keep: timesheets, including start times, end times, and break times; payroll, including proof of payment; contracts signed by both parties; pay advances, including an agreement signed by the TFW; transportation receipts if you are responsible for paying transportation. During an inspection, the inspector will always request these documents. The inspector will generally look for a window of time rather than request the entire 6-year period. The inspector will let you know what documents they require. The faster you submit these documents, the faster the inspection can be completed. As part of the inspection process, you will be required to submit documentation to demonstrate that you are compliant with the requirements of the program. Please ensure that you submit all the requested documentation. If you do not have a particular document that is being requested, please contact the inspector prior to the deadline and explain that you do not have it and why. There may be other documents that can be accepted instead, and the inspector may be able to determine another way for you to demonstrate your compliance. When submitting documents, please also ensure that you are submitting your documents on time. Failure to do so could lead to delays in your inspection and could result in a finding of non-compliance. If you cannot make the deadline, please contact the inspector before the deadline and explain why. They may be able to offer an extension depending on the circumstances or have alternate ways for submitting the documents. As an employer, you are expected to provide an abuse-free workplace environment. The definition of abuse includes, but is not limited to, bullying, harassment, physical abuse, sexual abuse, financial exploitation, improper restrictions, including restricting freedom of movement and association, and extreme hours of work. During an inspection, the investigator will want to see what steps you've taken to prevent abuse in the workplace. So they'll most likely ask for your abuse-free policy, what steps you've taken to train staff on recognizing and preventing abuse, how abuse is to be reported, and how you will ensure that there is no retaliation against reports of abuse. What steps you have in place to address abuse if and when it does occur. What reports you've received about abuse and what you've done to correct it. As a best practice, please post your abuse-free policy and common areas in the language of your workers. Service Canada understands that not all circumstances are in the control of the employer. So what is important is that you have a plan in place to prevent abuse and that you take immediate steps to address any situations that occur. So that concludes today's presentation. I will be sending a link to the presentation to Colin so that he can pass it along to the participants. Also note that the TFW program does change quite frequently, and that the presentation is for reference purposes only. So if you have specific questions about the program, we do recommend that you visit our website for the most up-to-date information. I do also have a quick questionnaire for feedback about today's presentation. I'll be sharing that in the chat. So if anybody wants to fill that out, it would be greatly appreciated. And yeah, that's today's presentation. We can move on to the Q&A portion. So if anyone has any questions, we can do that now.
Colin, you should already have a copy of the presentation to share with everyone. And I've also already posted the link to the feedback questionnaire in the chat, but it's also in the presentation as well if you don't have it when the time comes.
Perfect.
Yeah,
Thanks,
so I
Mark.
did receive that, Mark. Thank you. So, does anyone have any questions? We can just ask through the chat. Oh, there's one there. Can you see that question, Mark?
I can't. So it might have been asked directly to you.
Okay, and I will
don't
read
really-
it to you then.
Perfect.
It says, okay, it says, I heard that the validity of LMIA is being reduced to 6 months. Is that accurate?
That is unfortunately not a question that we're in the best position to answer. Give me one moment. I did see an email recently. So if you want to move on to the next one, I'm going to double check to see if I have that answer. But if not, that might be something we have to come back to you with.
Okay. If anyone else has a question, there's a Q&A at the bottom that you can type in a question. While we're just waiting, I do have a copy of the presentation, which I will email out to everyone who's on today. As well, on the last page, there was references and links to references. Those can also be found on our website, which is a great resource. So here's another question, Mark. Maybe you can answer this one. What is the maximum amount of hours a day a TFW can work?
So that's, again, highly dependent upon the local employment standards. And I'll be honest, I'm not up to date with the employment standards in Nova Scotia. However, I can say that there are specific requirements in terms of what's considered a normal workday, which is 8 hours. I completely understand that that isn't a normal workday in agriculture. There are going to be days where you guys have much longer days based upon being able to bring in, the harvest, all the rest of it. So for those days, double check, because there are provinces that do have specific maximums of 12 hours. And I will point out that excessive hours of work is something that we do potentially see as being abusive, right? So what I would suggest is make sure that you're getting their that they're volunteering for those days. I know that that's going to be the case 99% of the time with most of these workers. They want to work as many hours as they possibly can while they're here. So we do understand that. But just make sure that you're not exceeding the hours for the the provincial employment standards. And in general, I would say that if you're I wouldn't exceed 12 hours in general, because while that may not be necessarily in place in Nova Scotia, that's kind of what we've generally accepted as being an extremely long work day. So just bear that in mind. And but again, like I said, if it ends up being a one-off and there isn't that restriction in Nova Scotia, just make sure you document everything very well if you're going to be pushing lots of long days.
Okay, great. Another question just came in. Does the TFW need to fly back to Mexico City Airport, or can they fly to other airports that have direct flights from Canada?
So the requirement for the payment is that it's transportation to and from Mexico City. I'm assuming we're talking about Mexican SOP workers in this particular instance. So they would need to go back to Mexico City. If you are flying them directly to their home location, we're not going to have a problem with that for obvious reasons, because that's saving the TFW money, right? But the bare minimum is that they need to be flown back to Mexico City, and then they can make their way home from there.
Okay.
With regards to it, I am seeing that it looks like it's an LMIA validity period of 6 months. So just to be clear about that, that's not the duration of the employment of the TFW. Right? That's the validity of the LMIA. So if you apply for your LMIA, let's say in January, that means you can bring TFWs in on that LMIA until June, right? So it's not exactly, as doom and gloom as it might otherwise appear, because once the TFW is here, they're on a work permit, and the work permit has its own duration. So I want to specify there's a difference between those two. I will also add that shorter LMIA validity only applies to regular LMIAs. If an employer is in on the recognized employer pilot, those can have a validity of up to 3 years. Now, there's a whole host of issues. I know that it's not a program that's going to work for everyone, so I just want to emphasize that. But that is an alternative. Sorry, I think it might be 2 years, but the recognized employer pilot does have longer validities for their LMIAs and is a separate pilot, but it won't be around forever unless it's successful.
Okay, thanks.
Just also, in case anybody's thinking of applying for that, it's really easy. You just file your normal LMIA application and you check a box. That's all you have to do to qualify, provided that you meet the qualifications.
Okay, and that person just asked another question, said as a follow-up, if you need workers in the spring for planting, for example, and the fall for harvest, then you would need to apply with 2 separate LMIAs in the year?
Yeah, if there's going to be a break in terms of that employment, yes.
Okay. Another question just came in. If you don't have housing accommodations on farm, who is responsible for paying for off-farm accommodations, i.e. in an apartment?
So I mean okay. So that's a bit complicated again. So under the regular agriculture stream for low-wage TFWs and under the seasonal agriculture worker program, you are responsible for providing housing. There are some other areas within the agriculture stream, though. For example, if you have high-wage TFWs that are being brought in, that might not be under the main agriculture stream, in which case, like let's say you're bringing in, I don't know, someone specialized in horse breeding, because I've seen that before, where the TFW was very high wage and was brought in and ended up actually being considered a high wage TFW instead of being an agriculture stream TFW. And they ended up being the employer was no longer responsible for housing at all. I also know that there are some farms where they need to bring in, for example, a mechanic, right? So if it doesn't fall under the agriculture stream or the SOP stream, you may be responsible for ensuring that affordable housing is available with the low wage stream, which has its own set of requirements. I believe it's the CMHC requirement is 30% of the wage. Housing has to be within, fit within that, within 30% of the gross wage. But that's again outside of agriculture and SOP. So under the circumstances, you don't need to provide housing.
Okay, thanks. I also want to let people know that we also have a database of translators. If anyone requires that service, they can just reach out to me. For any of your temporary foreign workers that don't speak English. There's another question. For SOP workers who would more than 8 hours per day for planting and harvest, the requirement is to get the workers' agreement. Can this cover the 2 periods mentioned? I believe the presentation said a sign off for each day, ?
So at the moment, the current requirement is a sign off for each day. We are aware of the fact that this represents an administrative burden on employers, especially considering the fact that for the most part, TFWs are jumping at the chance. So it is something we're looking at, but I don't have anything concrete yet, so I can't provide you with a different answer until that comes into force. So at this point in time, each day, we are aware of it, we are working on it, and I hope to provide you guys with something different next time we talk.
Okay. Wait a couple more minutes to see if anyone else has any questions.
I have now, by the way, found where the Q&As are, so
Oh.
I will keep an eye on it. I was looking in chat.
Okay, well, it looks like there's no more questions. So I just want to thank Chloe and Mark for spending this time with us today. Thank you for taking time out of your busy days. I also want to thank everyone else for joining us here today. Again, I will send out the presentation to you, and it has been recorded, so it will be up on our website as well next week. Okay, so everyone.
Jump in.
Yep.
Jump in really quickly here. If anybody has any further questions that they haven't thought of and they, leave the call and they're like, oh my God, I should have asked this, please let Colin know. Colin and I discussed this at the beginning. He's going to gather any questions, send them on to us, and then we will happily answer those. Our aim here is to provide you guys with the information you need and help you guys be compliant. So absolutely.
Yes, absolutely. So everyone has my email address when I sent out the invite for this webinar. Certainly send off any questions that you have, and I will forward them on to Mark and get answers for you right away. Okay. Well, thank you very much, everyone. I appreciate it. Enjoy the rest of your day.
All right. Have a wonderful one, everyone. Thank you for having us.
Bye. Thank you, Colin.
Bye now.